Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 174 of the NCDWI Guy podcast. On today's episode, we are talking about the sometimes difficult to navigate waters of representing a client on a DWI that has a passenger under the age of 18 in the vehicle, the grossly aggravating factor of having a kid in the car. And so we're going to kind of walk through how to have a conversation with the client about that during the initial consultation. We're going to talk about some strategies for preparing your client for sentencing, for how to navigate as you're kind of working through the case in the courtroom, and then how to defend a client on this issue, potentially if you're attacking that grossly aggravating factor at a sentencing hearing. So we're going to walk through all those things. Before I dive into today's episode, just wanted to kind of offer a very brief reflection. I was walking up the stairs to the office today and just was reminded as I opened the door, there was something about maybe the magic of the morning, the sunshine, about how grateful I am to be practicing and doing what I do. And I think a large part of that has to do with the people that work here on the team at Minnick Law. There was something that was very welcoming about walking up those stairs and as I turned the doorknob, just feeling this like overwhelming sense of gratitude about the team that we have here and the place that I get to work. So I just wanted to share that gratitude publicly, because I do think that if you surround yourself with great people, obviously you want to love what you do. You know, subject matter is important, and we are very passionate about the work that we do. But in terms of quality of life and the joy of practicing law, I think that having a team of great A players, of great human beings that surround you at your place of business is critical to thriving in your particular practice. So I just wanted to share that moment of gratitude and really say publicly thank you to my team for making this such a great place to work. So diving into our subject matter of the day, again, we are talking about defending a DWI client that has a child in the car, somebody that is looking at level 1 sentencing or potentially higher, but typically at level 1 sentencing, because of that gross aggravating factor of having somebody in the vehicle at the time of driving that is under the age of 18. So what does this statute actually say? This is North Carolina General Statute 20-179, subsection C, subsection 4, 20-179 C4. Driving, so this is describing the different grossly aggravating factors, and this is the last one. Driving by the defendant while, 1, a child under the age of 18 years is in the vehicle. 2, a person with the mental development of a child under the age of 18 is in the vehicle. Or 3, a person with a physical disability preventing unaided exit from the vehicle is in the car at the time of the offense. I have never personally had a case with numbers 2 or 3. I think it would be probably very difficult for the state to allege or prove, or even for an officer to really kind of be thinking through number 2, person with the mental development of a child under the age of 18 years. that would be, to me, a extremely difficult thing for the state to prove, because an officer, generally speaking, is not going to be somebody that's an expert in human psychological development. And so really the only way to prove that would be to have like a doctor or psychologist come in and testify about that. So that would be a difficult burden, in my opinion, for the state to prove that. I've never seen that alleged person with a physical disability preventing them from an unaided exit. That is something that I think would actually be routine, and probably something that has not been caught by officers, or just not kind of front and center focus. But just remembering that those are two additional ways that under C4 that gross aggravating factor can apply. But on the show today, we're really just going to kind of zero in on a child under the age of 18 years old being in the vehicle at the time of the offense, because that's the most common one, and one that I see routinely in practice. So kind of the first thing to think through is how to have a conversation with a client that calls in about this. If you get a call from a client that, it's their first DWI, a lot of people have talked, with a friend or family member before they call a lawyer. They might have some sense just from other people that they know being charged with DWI about what the ramifications are, that they're maybe looking at some community service, that they're looking at having to do an alcohol assessment and classes. I don't think that most people that call in on a first offense DWI that have a child under the age of 18 in the vehicle are prepared for the sentencing and driving consequences of that, unless they've done some research online or by some odd chance know somebody else that has been in that similar situation. But unless they've really done their own research, generally speaking, I don't think that they are kind of prepared for what the realistic kind of level 1 outcome looks like. So I think it's very important in intake to spend a lot of time with the client talking about kind of the difference between, if the person had been charged with nobody else in the vehicle versus with somebody else in the vehicle, just so that the client can kind of see the difference that this one factor, this one circumstance kind of changes the sentencing outcome that they are looking at. So I can remember specifically a client that called me early on in practice. She had been out with 2 other families on the parkway, 6 adults, so 3 couples, a number of kids. I want to say somewhere around like 10 kids that were, celebrating with them. And my potential client at the time was basically celebrating her birthday, was up on the parkway celebrating her birthday. This was mid-afternoon on a weekend. They had between the 3 adults, I want to say they had shared 2 bottles of wine. Her husband was on the phone. He was, communicating as well. And so, a kind of, minimal amount of alcohol consumed. I believe that she had 2 glasses of wine up on the parkway over a couple hour time period. She gets back into her vehicle. One of her girlfriends was, sitting up in the front passenger seat. I think they had about 4 to 6 kids. I can't remember the exact amount in the back of the car. And, there's 2 or 3 cars in this caravan of vehicles that then is leaving to kind of go back to their home. And so on the way back, after they exit the parkway and get back on the main road, my client is stopped for speeding. And ultimately, the officer charges her with DWI, does field sobriety tests. Kids are all in the vehicle watching this. She is taken down to the station and blows a .08 at the station. So just right there at the legal limit. And as I was having the conversation with her about this situation, I could just kind of feel the almost wall of disbelief going up about the punishment that my client was facing for this situation. I think that there is so many times where somebody has a drink at dinner, with his or her family, is heading home, is at a party on a Sunday afternoon with some other families, is heading home with kids in the car, and there's just a real shock value in terms of the impact of this one circumstance, a child being in the car, having on sentencing. So it's really important in the initial consultation to kind of talk through the difference. To me anyways, I almost always communicate, here's what we would be looking at if your kid, or whether it's somebody else's child, your nephew, whoever it might be, if there was not a kid in the vehicle versus there being a kid in the vehicle, because I think it's important to kind of say we're not kind of in like normal territory. What I'm telling you is not some sort of fear mongering, or you just having your expectations wildly out of place. This one factor truly changes the game when it comes to the sentence level that you are looking at. Something that I've said quite a few times in consultations, and it's based on my personal belief is, I'll tell them, I think that there are plenty of judges across the state of North Carolina that in these circumstances, you got a client that's got a .08, a 12-year-old in the vehicle, stop for speeding, no accident, no other issues going on. I'll tell them there are plenty of judges in the state that in these circumstances, if they could, would give a community service sentence only, basically seeing this for what it is, as a first offense, a first mistake, a learning opportunity, would give you basically the absolute minimum sentence, just like any other person charged with a first offense. But I will tell them the state legislature, our North Carolina general statutes, don't give the judge that discretion. There are minimum sentences that must be imposed. And again, I always talk about the maximum as well, but there are minimum sentences that the judge has to impose based on the fact that there is a minor in the vehicle. It's out of the judge's hands. It's out of the judge's discretion. There are sentencing guidelines that apply, and the judge, no matter how much of a bleeding heart they might have about this situation, or how compassionate or understanding they might be about this situation, does not have the authority to waive jail time unless some of the other conditions that we're going to kind of talk about in sentencing preparation apply. So I think if you can kind of, I think a lot of clients that call in with this, because of the fact that there is a note about their kid being in the car, sometimes they are charged with misdemeanor child abuse. And if that charge is charged, I really think there's almost nothing worse in terms of psychology of a parent than being charged with misdemeanor child abuse. I mean, it is truly a wrecking ball of a charge, much more significant than the DWI, because effectively, what does that charge say? It says you are a bad parent. That's what the charge says. So I think there's a lot of kind of damage control and kind of rebuilding of character that needs to get done during the consultation. And basically, if it truly is, an outlander, mistake that doesn't, this is not something that is indicative of somebody that's got a real issue with alcohol based on your conversation. I think that there is some character buildup that you need to do during the consultation, because really, again, being told publicly by means of this charge, misdemeanor child abuse, or the sentencing circumstances going on with the DWI because of there being a minor in the vehicle, I think clients come into the consultation or during the consultation just feel completely deflated. And I think that, some people, take different approaches to that. Some really beat themselves up. Others kind of take a defense mechanism of, I didn't realize how bad this was going to be. I wasn't trying to put my child into a dangerous situation. There's some sort of psychological safeguards that you'll see going up during the consultation with a client that is facing the gross aggravating factor of having a child in the vehicle. So I think you need to really communicate about, why this situation is extremely different than the normal first offense DWI case, what the statutory framework looks like, and then basically offer a game plan moving forward. Now, in terms of the sentence level, obviously, if there is a child under the age of 18, it doesn't matter if there's 1, 5, 15, it's one gross aggravating factor. So unlike prior DWI convictions within 7 years, it doesn't matter how many kids are in the car. If there's 1, the gross aggravating factor applies, and it's 1 gross aggravator. If there's 10, there's 1 gross aggravating factor that applies. It doesn't become 10 gross aggravators. So it's not a per child gross aggravating factor. It's basically 1 or more children under the age of 18 makes this a gross aggravator. This is also the only gross aggravator that automatically elevates the sentence to a level 1. For any other grossly aggravating factor, you have to have at least you have to have 2 to get it up to level 1. This one makes it level 1 automatically. So that obviously, again, is a huge difference maker. So when you're talking about the consequences, obviously at a level 1 sentence, the maximum statutory punishment is 24. The other thing to note on that front is that, again, if there's a kid in the car and a prior within 7 years, or there's a kid in the car and the person is charged with DWLR impaired, because their license was revoked for a DWI that they had gotten, more than 7 years ago. But typically I see this with a prior DWI conviction within 7 years, they're still facing level 1, because it's not as though the gross aggravating factor of having a minor in the vehicle is the value of 2 gross aggravators. It's just a gross aggravator that automatically elevates it to level 1. So if you have a client that is charged with DWI, has a minor in the vehicle, and also has a prior within 7 years, it's still level 1 sentencing. So the second gross aggravating factor of the prior DWI within 7 doesn't really make any difference in terms of the sentence level. That might have a massive difference in terms of the consequences at a level 1 sentence, but it doesn't change the level 1 sentence. So, the person that's charged with level 1 or looking at level 1 sentencing, just as a quick reminder, is facing up to 24 months in jail. The minimum jail time that a judge can impose at a level 1 is 30 days. Now, again, we'll talk about the way around that in terms of other options, but that's kind of the mandatory minimum and maximum of the sentencing courtroom wise at a level 1. Also, even if this is a first offense, the suspension time from the DMV is still going to be 1 year. So it doesn't make the suspension period for your client's license longer, again, assuming that there's no other gross aggravators that apply. If this is the only gross aggravator, basically it's still the minimum 1 year of license suspension, but huge difference. Client is not eligible for a limited driving privilege post conviction. So that 1 year of license suspension is a true 1 year of not having the ability to drive. Now, why is that so important? Well, if your client has young children, then generally speaking, they are probably a person that is most in need of a driver's license, getting their kid back and forth to school activities, school itself, extracurricular activities. That really is going to put a strain potentially on if it's a two-parent home, on the other parent. If this is a single mom or dad, this is really going to cause a lot of issues in terms of being able to help get their child back and forth to where they need to be. And that's one thing that has always been a little bit bizarre to me about the level 1 sentencing. I feel like on the driving privilege, there really should be a caveat to not being able to issue a limited privilege at a level 1 if this is the sole reason of level 1 sentencing, because ultimately at the end of the day, this is probably primarily hurting the child. I mean, if there's anything that basically requires driving that is not like 100% essential, like getting back and forth to school, a lot of those activities likely are going to get cut for the kid during this time frame. So I think that from the client's perspective, to me, that is one of the most like debilitating parts of the initial consultation, is talking to my potential client about the impact that this is going to have on driving. Because again, as a parent, in a lot of ways, in almost any part of our state, that's a humongous problem in terms of being able to get your kid back and forth everywhere they need to be, in addition to still getting all of the normal household items that are required to maintain your family's life balance, basically just being able to provide, being able to work, all of those kind of normal things, but then also having to kind of play chauffeur very, very frequently. And as a dad of 7 kids, I feel like my full-time job is being a chauffeur, and then I do law on the side. I mean, I feel like I'm literally like spending, I think last school year, we had kids at 4 different schools, and I was thinking to myself, I'm spending probably 20 plus hours a week in the car. My wife was spending basically similar amount of time in the car, running people everywhere. And so again, it is a humongous weight. And so I think just being able to sit in the consultation and really allow your potential client to digest that, as opposed to just like spewing information at them, to me, that's the better general approach to a DWI consultation in the first place, but particularly where there's these kind of ramifications that your client is facing in terms of the courtroom consequences, but almost more importantly, in terms of the driving consequences, because their wheels are turning. They're, for the first time, potentially imagining, what does a year of not being able to drive at all look like? And I think for a lot of people that spend that kind of time a week in the car, 20, 30 hours in the car, it's almost impossible to imagine that situation, and I've had clients that are like, I won't be able to do this, like that's literally their response, is I'm not going to be able to make it, I'm not going to be able to get my kids to school. And so again, just realize that there is a moment of shock that is happening for a lot of clients in that initial consultation regarding the criminal consequences and the driving consequences. None of this is to say that sentencing factor is not appropriate. Driving with kids in the car is extremely serious. And so I get that. I mean, I'm not trying to say that that's not an appropriate sentencing ramification, but I do think it's important to really sit in the consultation with your client as they start to process the reality of being, without a driver's license when they're trying to provide for their family of being without of having to figure out how am I going to, be away from my family for 10 days or for 30 days. So those are some things that really you need to put on there, or give them the freedom to kind of let their wheels spin a little bit. And as they kind of start to ask questions, be there as a appropriate support pole. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWI-GUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. So in terms of the sentencing, routes that you can go, it's important to lay out for the client again what that minimum sentence is under level 1, 30 days, and explain to them. And I think almost every client that I've ever had level 1, with this being the reason that they're the level 1, has opted to get continuous alcohol monitoring installed. So 120 days of CAM basically allows the judge to reduce the 30-day minimum down to 10 days. So continuous alcohol monitoring is typically a very high incentive. I mean, there's few people with a family that they're providing for that can really be out of commission another 20 days. So no matter how expensive continuous alcohol monitoring might be, the idea of not being able to kind of help support their family and be there for their kids for an additional 20 days than what is required minimally is not going to be an option. So again, you can, by having 120 days of CAM, reduce the minimum 30-day sentence down to 10 days. The judge can give up to 60 days of pretrial credit towards that minimum sentence, or towards that 120-day CAM requirement. And so that potentially, and for most judges, I think most judges that I've ever been in front of with this situation of being at a level 1 for this reason alone, have been pretty understanding that, especially if it's a first offense, this really is a massive sentencing difference. And I really can't remember a time where I've seen a judge give more than the minimum. I'm trying to think, and I can't think of any situation where that was, beyond the minimum amount. If there haven't been any prior DWIs, this is the only reason that they're looking at level 1. I think most judges realize the sentencing consequences are pretty extreme already, even at the minimal level, for somebody that has basically gotten this charge for the first time. So level 1, using the CAM, you can get down to 10 days. That 10 days, the judge has the ability to replace that minimum 10-day sentence with 10 days of inpatient treatment. So, I've had many clients facing this situation that have done 10 days in inpatient treatment along with 120 days of continuous alcohol monitoring and not been required to do any time in jail. So again, these are the options that you want to explain during the consultation or shortly thereafter, because a lot of these things require proactive planning. The inpatient treatment can take time to get into and get set up. The continuous alcohol monitoring device can take some time to get installed, or even working through like the financial logistics of making these things happen. The earlier, to me, that you can put this on your client's radar, the better off they are going to be, because parents, clients in this situation need to be planning. So that's something that would be worth having a conversation about early on. The other thing that happens a lot of times, whether or not there is a misdemeanor charge for child abuse, is that DSS can become involved in the case. I've seen DSS involved in some of these cases and not involved in others. I'm not exactly sure, when they become involved, why. I don't know exactly what the requirements are. I believe that if there is a charge for misdemeanor child abuse, that is something that DSS is required to do an investigation about. Now, how they get notified of that, again, I don't know exactly what that looks like, because I feel like I've had clients where they were charged with misdemeanor child abuse and did not have a DSS case open. So, generally speaking, this is something that your client should be prepared for, a DSS investigation, which again, you should have a conversation about that during the initial consultation, or there already may be a DSS investigation involved as you are, before they've even contacted you about the case. Now, if DSS is involved, then one of the best things that, to me, your client can be doing for both the DSS end of things, but also for court, is to actively comply with the requirements of DSS. And this, I don't do a lot of DSS. I don't do any DSS casework. So for any DSS attorneys out there that handle those cases regularly, there may be some disagreement about this, but generally speaking, if you can get a letter from the Department of Social Services that the case investigation has been closed, that your client has complied with all requirements, that they in fact are found to have a safe home for kids. To me, that's a letter that's going to go a long way in the courtroom in terms of either being able to negotiate the dismissal of a misdemeanor child abuse charge, or in sentencing, being able to tell the judge, here's what, my client, has done since then. They did a safe parenting class, through DSS. Again, that letter is going to be helpful, whether it's in terms of actually getting a charge, the misdemeanor child abuse charge dismissed, or in terms of just sentencing. But during the consultation, if you've got a client that calls you within 24 or 48 hours of the situation, you're going to have done your client a major favor if you have prepared them that DSS might become involved, because there's really, again, few things worse than, basically DSS knocking on your door and saying, hey, we're investigating you because, again, on paper, you're a bad parent. That's a just terrorizing situation to become involved in. And so, again, even without there being much guidelines of here's XYZ what you should do when that happens, I do think it's important to at least put that on your client's radar so that they can kind of be mentally prepared for that situation. So again, in terms of planning and consultation, those are some big picture ideas on how to plan for this situation. Again, I think this is a massive mental stressor for your client. Facing a misdemeanor child abuse charge is a massive stressor, and knowing a lot about your client's background and current situation can also help you navigate that, the importance of having that misdemeanor child abuse charge dismissed. That may be a massive problem for your client depending on their employment, so that this is just something to be extremely delicate and give a lot of time over in the consultation. So now let's move on to just a couple of approaches when it comes to kind of the case approach. One question: if there's no misdemeanor child abuse charge, if there's a charge of misdemeanor child abuse, you are probably not going to be able at a sentencing hearing to avoid, conversation by the judge about this charge. But in terms of the case strategy, there have been a number of times where there was no, my client had a minor in the vehicle, and there's no indication by the officer about there being a minor in the vehicle on the citation. That box is not checked. There's no indication about that on the paperwork. And so generally, the goal on that type of case is to have my client prepared for level 1 sentencing. But then obviously, if the state does not allege that as a gross aggravating factor, to draw no additional attention to that. So whose burden is it to prove the gross aggravating factor of there being a minor in the vehicle? It is the state's burden beyond a reasonable doubt. 20-179 A1-2. So that's 20-179 A1-2 is basically the requirement that all grossly aggravating factors under the DWI sentencing structure and aggravating factors as well. All aggravating factors must be proved beyond a reasonable doubt. This is a gross aggravator that is determined by the jury in superior court, while prior convictions under the statute can be determined by the judge. This is a jury determination in terms of this specific gross aggravating factor. So again, if there's no indication in the note citation about there being a minor in the vehicle, this is something that you obviously do not, as being a good, zealous advocate for your client in the courtroom, you don't want to draw any attention to that. So having your client prepared for worst case scenario is still the right thing. Even if there's no, you get the citation back after your client's called, and there's no indication of there being a child under the age of 18. You don't know if the officer is going to appear in court. You don't know what other notes or conversation there might be between the DA and the officer before the ultimate court date. So you want to make sure to have your client prepared for level 1 sentencing, even if ultimately, because that's not introduced by the state as a gross aggravating factor, and therefore the judge doesn't find that beyond a reasonable doubt as a gross aggravator, your client looks then at level 4 or 5 sentence. You want to be prepared for worst case scenario. So in terms of proving this beyond a reasonable doubt, I do think that there are some situations where proving this would be a issue. And so basically, if you've got an infant in a car seat, if the trooper sees that child in the car, that's going to be a pretty difficult gross aggravating factor to contest at a sentencing hearing. If you have, a client that has, 2 16-year-olds in the back of the car, that is something where the state proving beyond a reasonable doubt that gross aggravating factor exists may be something worth contesting at a sentencing hearing. So this all just depends on obviously the particular circumstances and facts, but I feel like a lot of times the gross aggravating factor is proved in one of two ways by the state, or the state indicates on its form one or two things, and that's basically either the appearance of the passenger, it appears that person is under the age of 18, or there is a statement by passenger or other passengers or the driver, your client, about the age of the passengers in the vehicle. So generally speaking, again, you might have a rare situation where there's an officer that gets IDs of the passengers that, shows 16, 17. They still have to get those IDs into evidence, or maybe they never make a copy of the ID. They just say, I saw this. But if they don't have some sort of, birth certificate or a certified copy of a driving record showing that there is a passenger under the age of 18 in the vehicle, in terms of that matching up with that person's date of birth. They're really either going off of a visual clue of age, or they're going off of a statement about how old that person is. And so if you've got a client that has, somebody, generally speaking, I mean, this again could be somewhat of a variance, but generally speaking, between 14 and 17 years old as the cause of this gross aggravator, being able to prove that beyond a reasonable doubt, to me, is something that could be called into question. That's not the right approach to take in every particular situation. But if it's the state's burden to prove this beyond a reasonable doubt, if they're going off of just hearsay evidence, statements by the passengers, I looked at a person's ID card and here's what that said. All of those things that's hearsay. It also potentially is a violation of the confrontation clause if this is something that is being called into question during a sentencing hearing. And again, in district court, the judge is sitting as a jury of 12 because this is a sentencing factor that is determined by a jury in superior court. So that is if that's the way that they're trying to prove that, I think one of the legitimate arguments is that there are people that just don't look the actual age that they are. There's people that look younger than their actual ages. There's people that look older than their actual ages. I mean, if you watch the what is it, the Little League World Series, you see some of these kids that are purportedly 12, and I think there used to be a little bit more of a fudging of birth dates for some of these kids. But even now, I mean, some of these kids just are, look like they could be playing college baseball. I mean, they're just, massive frame. I mean, there's kids that are 16 with, crazy facial hair. There's, 25-year-olds that look like babies. So, I mean, it just, I think it's a legitimate argument if that is the sole grounds for, proving age is what, one of the passengers said in the car, what the actual person, if they're not testifying at the hearing, what they said, that's something that is worth considering contesting, because it is something that the state has to prove beyond a reasonable doubt. So worth looking at fighting that, because again, primarily, obviously there's the criminal consequences, but primarily, if a judge does not find that the state has met its high burden in regard to proving that gross aggravating factor, even if you just pled straight guilty to the DWI, and the only hearing issue for the judge to consider is the age of the passenger for determining whether that gross aggravator exists or not, you could potentially get your client then a 1 year limited driving privilege that would allow for driving during that 1 year of suspension. So again, certainly something to be thinking through. It's something that is worth, bouncing off some other lawyers, whether that's in your office, in your jurisdiction, talk to other attorneys about some of these issues. As always, you can give any of the attorneys at our office, including myself, a call about your particular circumstances if you want to get another set of ears, another set of eyes on your case. These are some of the factors to be thinking through. It's a difficult situation for your client. The stakes are high when there is a kid in the car, and it's our job to help get our client prepared, to have them understand the things that they are facing, and to plan strategically in the best possible way for moving forward with their case. Hope this information has been helpful to you, and I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.